That will depend on a number of things. Firstly, if you've been charged with a relatively minor charge that can be dealt with summarily in the magistrate's court, then the matter will come on for trial much sooner than if you've been charged with an indictable offence that has to be tried in the district court or the Supreme Court. And in any event, there is a process that has to be played out in the magistrate's court, which involves the prosecution preparing and disclosing to the defence details of all of the evidence it intends to lead in support of the charges. Once that's happened, then the matter has to be listed for a hearing in the magistrate's court, either a preliminary committal hearing in the case of the more serious indictable offences, or a summary trial in the case of charges that can be dealt with summarily. Either way, in most magistrates' courts in Queensland these days, that hearing in the magistrate's court will usually take some months to eventuate. Of course, it depends on where the court is and how heavy its current workload is as to how soon a hearing date can be listed, but it is not unusual for that process to take up to several months. If the matter proceeds by way of committal hearing and the magistrate commits the defendant for trial in one of the higher courts, either the District Court or the Supreme Court, the Director of Public Prosecutions has a further 6 months in which to present the charge before the higher court. Usually that's done sooner than 6 months, but the DPP can take that long if he wants to or needs to. From there, the matter has to be listed for a trial, and once again, that process can take many months depending on the workload of the courts. Unfortunately, in the case of indictable offences, it's not at all uncommon for the process from start to finish to take 12 months and more to play out.